signed agreements or some confidentiality agreements. They have money who went for the speech. I got okay, do it when nobody else is here.
I'm not even a VMS guy.
That's surprising. Actually.
Yeah, I'm actually mostly Windows. I do Intune. I do.
Well, you know, I had a couple of years ago, somebody asked me a question in the PC case.
Mhm.
And I said, when somebody leaves your employ, take their laptop, bring a tech into the personnel office or the counselor's office,
Mhm.
pull the hard drive,
Yep.
tag it and bag it.
We've done that on
Because
2 occasions.
hard drives are cheap. Forensically imaging a hard drive and adding it to a big archive
Mhm.
is not terribly expensive. And the lawyer bill for you for improper dismissal is expensive. So the bottom line is, if you treat it as evidence from day one and put it on the stockpile until the statute, whatever the time expires, you have the evidence, you've got it witnessed, sealed, etc. And when the inevitable lawsuit comes, as it will some percentage of the time, it's like laying out a royal flush.
Yeah, it's definitely.
Well, you couldn't possibly have my hard drive. Hard drive? Oh, yes. We routinely archive departed employees' hard drives and their email folders, and we keep it until the statute runs down. So, yes, about the evidence you're concerned about. Oops.
Yeah. I mean,
It's amazingly, it changes it from he said, she said, to what it should be, which is a dispute resolution mechanism. When you have the evidence, it's a lot smaller, a lot simpler thing. Too many cases get really messy because somebody didn't preserve the documentation. And you get into he said, she said.
Yeah, it's definitely,
And
I mean,
if hard drives cost $100 a piece, that's not even the lawyer's time for setting up the appointment.
image the machine, put
And-
it on it.
No,
Don't even touch it.
take it out, bag it.
Yeah, it's basically a memory stick.
Take,
Solid state.
well, solid state you have to be careful about. They don't have the shelf life you have to be careful about.
Yeah.
But you can have a tech in your IT service department set up to do routine imaging, preservation, and documentation. It's a routine assembly line process. It's not a biggie.
OneDrive. It captures it.
You just capture it all to a dedicated storage array, log the control information, do the note. Let me go through the presentation. You'll see what I'm doing. Okay, VMS security. Document. Oh, this keyboard is different. 1 second. Oh, there it is. Sorry. Okay. Legal and technical are different. Frequently, they don't meet. Lawyers do legal. They worship things that work in the court system, that work with the regulators. They're not generally technophiles at the level you'd want them to be. The exception is some patent lawyers who started out as double E's or computer science majors and then went to law school. They are better. They know what not to do. Sometimes. But there are legal needs, and technical people are generally completely oblivious to it. Where was the backup? In my desk. If you tried that stunt with a blood sample for a drunk driving arrest, the case wouldn't even get past the judge saying, motion to dismiss, counselor. No evidence. Gotta be careful of that. It can get worse, and frequently does. There are technical measures to do it, and we'll go over how we want to address this. I'm not an attorney. I don't play one on TV. Everything I'm going to tell you, get a hold of your corporate legal department or your outside counsel and start asking questions. It's not so much a question of changing procedures instantly, but of exploring the issues and what the vulnerabilities are and how you want as a policy matter to deal with them. More later on that. It is two-way. You need to understand what legal needs. Legal needs to understand what you can do. Because they're as ignorant generally of what you're doing as you are of what they're doing. I've been consulting on digital evidence and forensics as part of my practice for a long time. I've seen all kinds of disputes. Many of them are misunderstandings. I have advised many attorneys, if you're going to an electronic discovery conference, which is now in the federal system mandatory, you better bring your tech backup people with you. This is like a diplomatic negotiation. The Secretary of State or the ambassador may be headed, or the chargé may be heading the meeting. But you bet they have their subject matter experts seated along the wall, listening to cue them in when don't do that. Stop. Don't go further. We got to, excuse me, I think the ambassador needs to answer a message from his office. Don't do that. We're in trouble.
Gonna be using Gmail for, sending emails to somebody that's related to business or.
This is a okay, this is a policy question. It's complicated. That movie title was a beautiful piece of phrasing in 2 words. It's complicated. People know each other, have friendships beyond work. People sometimes don't have access to their work email at home or where they are, for whatever reason. It's complicated. But yes, as a general rule, it should be in your procedures manual that you don't send business-related email from your personal address or receive at your personal address. And there's 2 reasons for that. One is that it's out of policy. That's neither here nor there, but I'll tell you the real reason. If you're caught, I'm going to have to do a dump of your entire personal email history. That means everything. And I'm going to have to pay to get it vetted. The firm is going to have to hire counsel to go through every single email you sent or received to your Uncle Charlie and your niece Diane and verify it is not germane to the subject matter request. If you fail to do that, you may very well be looking at sanctions, discovery violations, and courts are looking very askance at those. More later, the numbers can get big. I've testified numerous times and consulted numerous times on how to do things. Sometimes the IT people involved go, what do you mean we're going to do that? Yes, we're going to do that. And they say, why? I don't want to. And I will say, because if not, we're going to have a real bar brawl down at the courthouse. And that's going to be expensive, time-consuming, and risky. Because once you get in that kind of brawl, there's no way to know how a judge will rule. He may rule that you haven't made your case on excluding personal traffic, and you now have to deliver all your personal traffic to the other side. Awkward, that. I've been speaking on my first speech on digital evidence, I think was 1990 at DECUS. I contributed to the Computer Security Handbook from 1995 to 2014, the 3rd through 6th editions.
Robert, can I stop you real quick?
Yeah.
There's a case that's going on in Massachusetts that I'm very familiar with.
Mhm.
It involves government officials using,
Yep, that's out of policy, start,
district attorney.
out of policy.
How
Government
about,
business on personal email.
how about state police, detectives
Probably the same thing, I would guess.
using text messages?
And they will be subpoenaed. The problem is they'll subpoena everything. And
You'd be fascinated by this case that's going on right
it can get messy
Yes, it can.
very fast.
What if the FBI has all the information of everything?
That can also get messy. I had a case where a woman took her work laptop with her on her honeymoon and used it to store personal pictures. No, it was G-rated, but in her cultural background, you don't show third parties a picture of a woman in a bikini, a married woman in a bikini. And she had a problem when she left their employee and they decided to keep the laptop. Big issue. I'm law enforcement neutral. Sometimes the cops are right, sometimes not so much. All I want is fair play and accountability. If you do something that damages the evidence, you need to be held accountable for it. You can't clean up a crime scene and then only find the inculpatory evidence.
What if they created?
Like I said, I want accurate. I was very careful. I was very careful what I said. Hello, I seem to have competition in the ratings war. You want fair. You don't want evidence destroyed, either inculpatory or exculpatory. You don't want false evidence. You don't want misconstrued evidence. I have a case where the police came in and seized the BMS system, and the first action was to pull the power plug on the enterprise storage array. Matter of fact, the forensic report states all drives from the storage array were unimageable. Well, they were fast, wide, SCSI, and the forensic hardware kit doesn't probably include fast, wide, SCSI. Strike one.
Corruption of evidence.
You would think so.
Yeah.
Judge ruled no damage. Not intentional.
Unintentional.
Your Honor, I just happened to drop the gun in the water, so we have no fingerprints. Accident. As a side note, we're not far from where John Adams had some clients. Captain Preston and the Redcoats who fired at the Boston Massacre. He was successful at defending them. When people asked him, why are you defending them? The answer is along the lines of, we're fighting for due process, not trial by outrage. Same thing applies today. It's too easy to generate outrage. Justice is supposed to be blind and without emotion. Oops, sorry, wrong keyboard. Okay, legal context is not technical. You have a bug, you generally get to do over. You fix it, you patch it, you rerun whatever has to be run, you go backups and recover data, everything's cool. Sorry, once that gavel bangs down, the gavel banged down. Certain states have a reputation for upholding capital sentences, even when there's a question later. And the reason is we have to have finality of process. Yes, execution of the defendant is finality. You can't get back from it. You have to respect that rule. It's different than tech. You can get things wrong in tech and apologize and fix it. You can't necessarily fix a guilty verdict. In criminal, you can't necessarily reopen a civil trial. In legal, unless you have grounds, and finding that the jury erred or the judge erred in interpreting a factual question might not rise to the level of authorizing a new trial. You get one swing of the apple.
You're gonna love the Karen Reed case. You gotta look down on them.
Wording agreements are not agreements. I had a client case where it was a multi-party contracts case, and they all agreed to exchange all material electronically to avoid the million pages of paper, but they never agreed on formats or indexing. I got a gift of 100 some odd DVDs in an electronic, in the same package format, set done for importing into the same applications package for litigation support, with the indexes in more formats than there were parties. Some law firms seem to have changed formats halfway through the production. Production A and A1 and A2 in the same firm, different formats of keys. I spent over a week reorganizing the import indices so they could all be put into one data set. It was expensive. It was time consuming. It was unneeded. If people had just actually had a technical person at the table saying, stop, I need a format. How are you numbering this? Lawyers know how to do that, but they don't understand that it's not obvious. They know how to arbitrate numbering of pages. They do it all the time. They've done it since forever. But formatting is a whole different conversation. You have to have that discussion. Why producing an Excel spreadsheet versus producing the printout of the Excel spreadsheet is different. Printing a Word document versus the PDF generated by the Word document is different. Producing a database versus reports produced from a database is different. I can keep going on and on. These are electronic discovery is not an excuse for amateurism. You need professional IT involvement on all sides. Yes, it may mean the two technical people or three technical people sitting at a table with the lawyers with associates at their hands negotiating formats. You may have to get an outsider referee who's IT technical to arbitrate or lead the discussions. But you have to do this. It's not, we got an agreement on this electronic discovery. All you're buying is litigation downstream. I've seen it happen innumerable times. They say they'll produce electronically. I get a PDF file of a database. That's not useful. You may not want the person advising counsel to be one of the fact witnesses in the case, or the custodians. You may want an outsider, because there may be situations in which an insider can't see things. Some data may be proprietary, restricted, and an opponent can't see it. I've had cases in patent law where I was authorized to see source code, but the client was not. It was attorney and expert only.
Classification.
It's a classification problem. It's the same as in the defense sector. Yes, I can tell you this is airdropped. Can you tell me which platform? No. Can you tell me the altitude? No. Can you tell me? It's what you can and cannot say. Answer the question, please. There may be reasons I'm asking it, but I have to be I can't transmit information out of the compartment. I can look at your information, I can look at their information, but I can't give you their information. It's like when you see indictments released. The defendant, co-conspirator 2. Because there's a reason why they're not identifying the co-conspirator. Proceedings are adversarial. That's a good thing. But it means you have to be sane about it. The other side isn't helping you, except unwittingly, of course, sometimes. But you need somebody who's sitting at your counsel's elbow, listening to the technical details. Somebody says, witness says a 747 can fly 12,000 miles with this load. You need somebody sitting next to him or an engineer saying, being able to write a note on sticky shit. We're alone, so I can say that. No, I've had this happen. I had a witness testifying in a deposition, and I was following along in the source as he went. And I was very, very unashamed of, no. I was following him. He moved the line. He flipped the page. I flipped the page. Very open about it. And he was sweating. Because I was looking like somebody who was, and I was actually checking every statement he made against the source he was reading from. He knew it. I knew it. My attorney knew it. And his attorney knew it. Great way to make sure you don't have problems. The fatal attraction case boiled down. One of the issues in the Carolyn Warman's case was the MCI bill. There were two MCI bills proffered. One with the phone call and one without. The question was, which one was a forgery? MCI had to cough up its applications programmer to testify which version of the billing program was which. Hint, do your applications print out version numbers? Do you have a log of when version numbers were used under what circumstances? When you migrate from one version to another? These are all questions that come up as to authenticity. Can you prove files are authentic? Or that somebody could alter it to be convenient? Morgan Stanley versus Sunbeam. Morgan Stanley claimed its email backups were destroyed in the 9/11 attack. It later came out that they were in a warehouse in Jersey, but the IT felt it was too much effort to unpack them and search. The judge in Florida was very impressed with that explanation. He did a directed verdict against Morgan Stanley, and it was not for petty cash. It was a biggie. Willful discovery violation. That leads you to very quickly to a directed verdict, which means I don't care what you said. Anything where this evidence would have applied is to be construed as against you. Because if it had been in your favor, you would have produced it. That can be very bad. And I'm not trying to crack a joke. Fortunately, something higher up the decision tree broke the other way, and the email issue was no longer relevant. That's a very thin reed to depend on. If it doesn't exist, you're swearing an oath that it doesn't exist. You lie, that's called perjury. You can get a directed verdict. How big it can be depends on how big the case is. That could be more expensive than the actual offense, by orders of magnitude. The law requires reasonable, machine-readable document delivery. There's question whether that means worksheets in original native form. Note they didn't use the word native. This is a disputable object. That is a matter that lawyers routinely fight over. It depends what your technical case is. You need to know that you know the difference, but your lawyer may not. I had a case many years ago, so we have to discount it somewhat. But I went to the attorney on my side and said, we need copies of the floppies involved. And he went on a call without me, with the judge, the judge's clerk, and the opposing counsel, asked for copies of the floppy, and opposing counsel said, no problem. And a week later, I got a 9x12 envelope with photocopies of the floppies. Yes, sir. Now note that all three of the major parties involved had all agreed on this. I want to do that.
Be specific.
No, what you need to do is have a responsible IT person. Once again, it may not be, for various reasons, it may not be one of the insiders, but somebody who is familiar with what your inside looks like, who has been very well briefed, has to be sitting at the attorney's hand to know when to say time out. I have a question there I have to resolve. Before somebody says, no problem. Bad answer. Because once it gets signed by both parties and accepted by the judge, you got a problem if it can't be done. Alteration is an issue. Many people have altered things. Accuracy. The business records laws, which is what everybody uses to get this material in, is assuming classic forgery. 2 sets of books, whiting out things and erasing them. Computerized data is a lot different. But you have to guard against this because it's a question. The material has to be contemporaneous. How do you prove that? Knowing it and proving it are 2 different things. Back in grad school, we did murder boards. A murder board is a term that originated in the military. It's you get your 5 most aggressive questions, any number of aggressive questions you can lay your hands on, and they ring you out. Questions much harder than what you're going to get at the exam or at the evaluation. This is what a design review is supposed to be. A no-holds-barred beatdown. I've seen too many design reviews that are love-ins. The problem is the other side on the review, when you get to the real one, isn't going to be playing nice. You want the practice to be worse than the real thing. That's why batters practice with 2 bats. If you want to practice against a harder target than you encounter in real life. I recommend serious. A lot of technical people are not prepared for that kind of review. They're prepared for casual agreement type style stuff. If somebody starts asking tough questions, they can't handle it. And they're a very bad witness at that point. Another problem, people get sick, they leave the company, they forget. What happened 7 years? Where were you 7 years ago or last Thursday? Oops. Can't remember. But you are sure that's the backup you took? I think so. Sort of. Bad answer. You want to litigate that question? It's going to cost a lot of money. And the result is uncertain in the extreme. Judge is having a bad day. Opposing counsel is having a good day. You may have a very bad day at the end. What's the solution? At the source, document provenance. If you're in a big enough company, your personnel department probably has a notary on premises. Because certain documents that they do for employment and separation have to be notarized, like insurance stuff and the like. Well, when you take your backups, seriously consider notarizing an affidavit of provenance. Now, if the guy who took the backup falls down the staircase on the way back to his office, there's still a copy of the affidavit. Lawyers can get that in. The notary can witness, yes, I notarized that signature. They're real. It's in my notary book. You're building a context. These procedures save your bacon. When my lawyer does wills, he always gets both witnesses to sign affidavits of witnessing the will signing. Why? People die, they move, they have a falling out, whatever. you can't find the two witnesses, you may lose the will. If you have the affidavits notarized, here's the will, Mr. Court Clerk. Here's affidavit number 1. Here's affidavit number 2. Done. They are very useful. This is a perfectly legal procedure. It's understood by all people in the legal system. And if you do it right, it's solid. Oops, sorry, wrong key. The extra overhead, you back up 30 disk volumes. You generate 30 affidavits with the necessary information. What do? You call up whoever in personnel and say, I'm dropping by for coffee with my weekly backups. And they'll take out their notary stamp and you will sign them all in front of them. They will record the ID you're using, passport, state ID, alien registration card, whatever. They will notarize them. You will take them and either leave them with personnel in their safe or walk it down the hallway to the counsel's office. At that point, if something happens, counsel can go in and I have it. Where was it? In our safe. That will be trusted, generally. If you get into a situation where you have to file something, that affidavit is a line in the sand. You can file that in a public record in the courthouse. It doesn't disclose anything. It discloses cryptographic information unique to that file. It does not exclude contents of that file, but it does provide a guarantee that the file is intact. So you can publish it in the New York Times or the Boston Globe. Doesn't matter. It doesn't do anything except establish a third-party benchmark of the existence of the fact at a time in history. That's what is basically like the markers. You drive around your subdivision or the city, you'll find bronze or brass markers, bronze I think it is, in the ground by the U.S. Geological Survey for surveying as benchmarks. This is what that is. It's a benchmark that you can then go back to and say, this file is the file I produced on that date because here's the signature and here's the third-party storage and attestation to that document. That's your anchor. As I said, discovery litigation, it's very expensive. I've seen people blow tens and more thousands of dollars fighting over whether a piece of discovery is valid. It can be impressive. VMS has the checksum utility. It'll generate a SHA-1 or SHA-256 checksum. Backup. Maybe zip the backup so it's easily transportable by FTP, should the need arise. Do a checksum on the FTP, on the zip. Now you have something that you can take the file, run a checksum against it, get the result. Zip archives move as binary between most systems without a problem. We know how to do that. So you can checksum it and produce that as part of your checklist process. We unpacked it from the storage. We computed the checksum. We verified the checksum against the affidavit of provenance. They match. We then unpacked it. You see where I'm going? These are all steps that the judge says, I don't believe you. The other side, you can say, bring the other side in, bring their expert in. They can ride exit. They can drive. Do this, do this, do this. It all comes out the same way. You get the same result. Leave me alone. It's reproducible, it's process, and it's documented.
It's kind of neat. I mean, I'm not a VMS guy, but that's actually kind of neat that it has that ability.
That's how you do it. The affidavit contains who, what, when, where, file name, file length, SHA. There's also an NGS, there's a NIS NIST paper that if you take two different crypto checksums, the odds of them both being for a different file and being the same checksum is almost infinitesimal. Knock yourself out. Computer time is cheap. No, so all you're doing is you're crossing your T's and dotting your I's. I went through Canadian Customs Immigration many years ago. I was speaking at DECUS. And I had my session materials with me and some other stuff and the like. They asked, are you here to work? No, I'm here to speak at a conference. Are you getting an honorarium? Yes. Do you have an invitation letter? Yes. Are you an expert in your field? Meaning, there's a definition, expert here is in quotes, air quotes, actually in the free trade agreement, there's a definition of what qualifies as admittable without a problem. Here's a copy of my CV, my invitation letter. I sat there, I had a little folder in my laptop bag, I pulled it out, approved. But you don't walk into that unprepared. The rules are in one immigration officer. I don't have a copy of that publication. Do you? Yeah, just happen to have my copy in my briefcase. Funny you should ask. Would you like to copy it? My client on that project didn't have it with his documentation. He spent all night till nearly midnight fighting with them. And he then said, I now see why you got that letter. You have three things required. I had all three ready to go. Engagement letter showing me being paid in the US, CV, letter of instruction from client telling me to be in Toronto.
Basically the same thing I did when I was in Casablanca.
Right.
Why are you here? Not pleasure, business.
Yeah. When dealing with process, you don't open up questions. You answer the questions that are needed and therefore stop the problem right there.
Answer.
If you have it all laid out, the objection is very hard. If you have a gap, then it's open season. Notarize the affidavit. Legal penalties to the notary for false affidavits. You can get in trouble for that. Many attorneys are also notaries. Ask your counsel how they want to do it. They have their technical preferences and reasons. This is their patch. This is where they interface to you, they tell you what they need. You can offer it and show them the process. If somebody's indisposed or leaves the company or whatever, you have this notarized affidavit in the records, blah, blah, blah. It's all very neat. You have notaries available to you in-house often. Now, about VMS. Most forensic tools are all PC-centric with a little bit of Linux. You will not find a forensic tool that analyzes a file's 11 volume. And most technicians are Windows. They're technicians. They're not system managers or software engineers in general. They're technicians. They will run the program and the checklists in the program. They know what they're looking for, the way they expect to look for it. They are not going to decode your program. There are a few forensic, they are trained as techs. Most of them don't really know Linux very well. Most of them certainly aren't programmers. And most of them have never heard of OpenVMS. This doesn't matter if all your exculpatory evidence is on a VMS system in a custom application that your firm has used for 30 years. They're not prepared to go through it. If it isn't a JPEG, it isn't a Word file, PDF, Excel spreadsheet, or something like that, they don't know what they're looking at. He sees forensics doctrine, big on tag and bag, pull the drives. Pull the drives out of an enterprise storage array. Good luck. If you're following current HIPAA practice, they're encrypted at best. Without the encryption key, they're junk. On many arrays without the metadata, they're junk. On many of current generation storage, 2 generations back, let me go further. 3 generations back, like HSG 80s, it was volume managers. You had a RAID 1, RAID 0, RAID 5 volume collection. But the drives were 160 gig or something like that. Then you had drives where they would storage arrays like the P2000, where they would cut basically partitions across those volume sets. So you have 12 or 15 volumes on one 3-drive set, RAID 5 or RAID 1, no, RAID 0, sorry, striped, and split, if you will, horizontal. Those are comprehensible if you're really tenacious. You can work out where the home blocks are and start building a model, but software will not do it for you. Software is all set up for logical volumes. If it doesn't recognize it, it says tilt. Current generation storage arrays, like the MSA 2052 and others, are demand-paged bulk stores. They allocate logical block numbers wherever they want to. Without the metadata, good luck. But forensic, this is in the case of the government, even in the criminal divisions, the techs don't have the luxury of time and budget to start trying to even think about reconstructing it, even if they had the engineering data they needed to do so. Note, VSI doesn't have that data. You'd have to go back to the vendor, who would have to take you back to the engineering team and give you very proprietary information, which actually doesn't help you because it only tells you how the blocks, it doesn't tell you how they're what the shuffle is, it tells you the blocks are there. So you're completely hosed. It's unrecoverable in that mode. They have to be imaged at the logical volume level. But that requires being on the SAN, which requires a whole nother level of expertise. Passwords, GUIDs, you name it. You can do it, but I guarantee you very few capture teams in the government are in a position to do that for you. Most PC forensics assumes IDE, SATA, USB, or SAS. If it's anything else, forget it. They know about FAT, they know about NTFS, they know about X to N, maybe. And the tools are the tools, and they focus on the tools. They've taken courses on how to use the tools. They are not prepared to untangle anything that the tools don't untangle for them. The biggest tech item they do routinely training on is recovering a partition table and looking for home blocks in a FAT or NTFS system or an ext. But if you come up with something other than the codes they know, that's it. We're out of here. Oh, VMS can't you pull the plug safely, especially on storage arrays, without the engineering manual. By the way, the HSG doc, if you go query the HSG on the portal, you'll find a warning notice about bad batteries and power downs. That if your backup battery is bad and you lose power, you will lose all the metadata for the array. And it is an unrecoverable situation. It's in there in black and white. They ignored it. They didn't actually look. I have that testimony. They considered the actual testimony was, I am generally familiar with these devices, so there's no problem in unplugging them. And despite my testimony to the contrary, the judge ruled it didn't raise to the level of malevolence. VMS, especially the older systems, use fast, wide SCSI, not supported by most forensic toolkits in the physical sense. Tag and bag awfully makes a mess of things. Most field technicians can't discriminate between the cases. It's just a box with a bunch of disks in it. Could be PC with just a rack of disks with different SCSI IDs, or it could be a demand page storage array. They have no idea. They just pull the drawers. And I look at them and say they can't enter them. They say they must have been damaged. Now the fun part. Those logical volumes that are scattered around on an MSA 2052 disk storage pool. So let's be nice about it. A multi-disk mirrored. Well, do it striped. That's more fun. Striped storage set, multiple volume, logical volume, demand page onto that. How's that for starters of encryption? That's 8 megabyte blocks randomly shuffled. Oh, by the way, the volume is an NTFS volume, which has a VirtualBox vdisk. See where I'm going? Which has logical VMS disks on it. You can now throw up. You have to unwind. I think I named 4 or 5 levels of virtualization. Will the NSA do it with Iranian data? Yeah. Will the local crime lab do it? Probably not. And they may or may not allow you to do it for them. Now the fun part. If law enforcement bangs on your door, which they can do, you have a problem. They will assume you have complete documentation of your system. Want to have fun? Do a surprise audit. Ever see the movie? Ever read the book Money Changers? Branch bank audits in the old days. Right after closing, somebody, the most junior member of the audit team, walks up to the main door and taps on the door with a coin. And when the door gets opened, he flashes central audit, and the entire audit team piles in like rush hour in the T. They did a briefing in a closed room before the raid, kind of which branch they were hitting. They all moved around in ones and twos into the area. And the moment the junior kid gets the door open, it's crowd time. The name of the game is get every teller and every officer contained as fast as possible. And then you count everything and check all the account records. There's no warning for you to clean up. Do an audit on your documentation. Do you know where every disk wire goes and every LAN wire goes? And is it accurate? Because law enforcement will assume that's the case. And if you're not prepared for that, you may have problems. They will want to impound data and equipment. So you may have a problem. How can this happen? Well, suppose one of your staffers, well, let's start the easy one. An outsider compromises your system and decides to use your machines as a stash box for some material, which then gets detected. Oops. They will want to grab it all of you. You had it happen.
No. I actually.
Oh, you have to go?
I have to go around with everybody else, but definitely very informative.
Basically, you need to plan that one. You need to sit down in the conference room with a big coffee or and council and plan out what that contingency looks like. Who gets called, what you do. Just like you plan for a fire, storm, flood, terrorist attack. Yep. Glad you enjoyed it.
Thank you.